Good afternoon, everyone. Good afternoon, Mr. Millett. If you are ready to begin, perhaps you'd invite the usher to call Mr. Martin into the room.
Yes, thank you, Mr. Chairman. May we please have Mr. Martin back in the hearing room, please?
Good afternoon, Mr. Martin.
Afternoon, sir.
You're ready to carry on, I hope, are you?
Yes.
Thank you very much. Yes, Mr. Millett, when you're ready.
Mr. Chairman, thank you very much. Mr. Martin, I'd like to turn next, please, to the review of Approved Document B, which took place after 2011 as part of the wider review of building regulations and guidance, which I think led to amendments, certain amendments to ADB in a new edition in April 2013. Now, can we start, please, with Bob Ledsam's witness statement, CLG 3019465, page 10, paragraph 33. He says this, underneath the heading Coalition Government Building Regulations Deregulation Review 2011 to 2013, and he says, in December 2010, the then Building Regulations Minister, Andrew Stunnell, announced plans for a programme of work on the building regulations. This followed an invitation for ideas based on issued on 29th July 2010. His statement said that the programme will have a particular focus on deregulation and streamlining of the technical and procedural aspects of the regulations. This led to the 2011 to 2013 review of building regulations. The review was a comprehensive exercise in terms of coverage, but did not involve an in-depth review of all of the technical standards. The aim was to identify, quotes, quick wins, close quotes, for deregulation and system improvement. And then he goes on to identify the outcome. Now, just that last paragraph there, paragraph 34, do you agree with what he says there?
Yes.
And do you agree in particular that the aim was to identify what he calls quick wins for deregulation?
Yes, the government came in following the financial crisis that started in, I think it was 2008, and their focus was on trying to stimulate the economy by reducing the impact of regulation.
Yes. And do you, you could see the words invitation for ideas. Do you remember whether that referred or covered all parts of the building regulations and approved documents, including Part B?
Yes, Part B was involved, yes.
Now, the invitation, I think, was open to the public, wasn't it? Anyone could submit ideas or comments.
Yes.
Yes. And as Andrew Stunnell, I think, explained at the time, there was a particular focus on streamlining and deregulation. Is that how you recall it?
Absolutely. As I say, the objective was to reduce the economic burden of regulation on industry as a way of stimulating the economy following the financial crisis.
Can we go to CLG 3019136, please? This is a run of emails in October 2010. And if we go to the top email sent by you on the 25th of October 2010 to Ken Knight, we don't need to go through the entire background. We can see from the email below it that, if you just scroll down to the second one first, that he has sent you something and asked a question. Has the NIC-EIC proposal got legs? Obviously a follow-up, etc. And that, I think, is about the National Inspection Council for Electrical Installation Contracting, isn't it?
Yes.
It's about Part P, electrical safety.
Yes.
Yeah. Now, your response is as follows, and we need to look at that. If we can scroll to the top of the screen. Thanks, Ken. It's complicated, as with all things related to building regs. On the one side, there is a desire to reduce regulatory burden. In the Your Freedom exercise, there were a high number of submissions from ordinary citizens, probably electricians, calling for revocation of Part P, electrical safety, of the building regs. On the other side, we have NIC-EIC and other electrical safety campaigners calling for Part P to be made more onerous. The SIFOA event was part of an ongoing campaign. I think giving industry, i.e. the NIC-EIC, responsibility for the future development of the technical requirements contained contained in approved documents P would be a bit like letting Ronnie King write ADB, exclamation mark. It would save the department the cost of drafting the AD, but that isn't necessarily in the best interests of UK PLC. Given the number of responses on YF, that's your freedom, it's likely we will do something to Part P, although what we do is by no means clear. Now, just breaking that up, is it right that the invitation for ideas launched in the July of 2010 was part of the then government's Your Freedom exercise? In other words, a crowdsourcing exercise aimed at stripping away excessive regulation?
Yes, I think they were asking anybody to list any bits of regulation that they thought were unnecessary to bring them to the attention of government so that we could look to see whether we could remove them or not. Now,
in your statement, if we go to your statement, please, page 76, paragraph 199, at the end of the second to last line, you say this. In my email to Sir Ken Knight, I note that all things to do with building regulations are complicated by which I meant that where you are trying to balance deregulatory policy with calls for increased regulation, that creates an inherent policy challenge. Was the inherent policy challenge a matter that you raised at this stage or any other with officials senior to you or with ministers?
I don't think I would have done. I mean, it's a fundamental principle that there are two directions in which the policy gets pulled. That's the nature of policy work.
One direction being industry and the other direction being safety, or
in the case of safety regulation, I guess that's a summary. It's probably more complex than that, but that's the principle. Right. Is do you regulate more and achieve higher standards of safety, but in so doing, do you make industry inefficient and non-competitive?
To what extent do the ideas received by the department through the call for ideas process influence decisions on amendments to any of the regulations or approved documents, specifically in relation to fire safety?
I don't think there were many responses in relation to fire safety, as I recall. Right. As my email to Sir Ken suggests, there was a lot in relation to electrical safety, and I subsequently was heavily involved in a piece of work looking at the electrical safety requirements in the regulations.
Can we go to your statement, please, page 77, paragraph 202, a little bit lower down the screen? You say, in December 2010, the department produced a report on future changes to the building regulations' next steps, which detailed plans to take forward a programme of work to examine a number of areas to develop detailed proposals for consultation. The programme was to have a particular focus on deregulation and streamlining of the technical and procedural aspects of the regulations. In relation to Part B, the report noted that responses had focused on sprinklers and egress from a building for people with disabilities in the case of fire, and it goes on after that. As a result, I think you go on to explain that the provisions on means of escape for disabled people were kept under review, yes? Is that right?
Yes, I don't think we did any work on that.
Right. So what do you mean by don't think we did any work on it? Were they kept under review? Does that mean you didn't do any work on them?
Yeah, no, there wasn't an active piece of work in relation to that, as I recall.
So what does kept under review mean? I think we may need to turn the page to the top of page 78.
If you don't mind.
Yes, sorry. Let's look at that. The last sentence there says, in relation to the egress issue, the report stated that the issue would be kept under review. Does that mean just parked on the desk and not looked at, or does it mean constantly monitored?
I think it means it's something that we look at in the future, and there wasn't any specific plans to do any particular work on it at that time.
Now that doesn't therefore seem to have presented much in terms of challenge, does it? It just was parked.
I guess that's probably a fair response at that time.
And is it the case that, as I think you say, nothing was done on sprinklers because the call for ideas essentially had not produced a cost-benefit analysis which contradicted the analysis the department already had? Yeah,
I think those people that had responded in relation to sprinklers had argued that if, whereas the approved document at the time required sprinklers in different buildings in different situations, or recommended in the guidance that sprinklers will be provided in certain sorts of buildings, in certain sorts of situations. Some people had argued that the regulations would be simpler if it said all buildings must be sprinklered.
Right.
And you can see, yes, the rules would be simpler, but the cost to the economy would be greater.
And again, it doesn't seem to have been hugely challenging in that those responses on sprinklers were simply noted but not acted on. Is that a fair way of looking at it?
Yeah, as Mr. Ledston said, what we were tasked with looking for were things that were quick wins that could be done easily, that didn't require a lot of additional work, and would ultimately result in a reduction in the cost of regulation.
Were any ideas received as a result of this call for ideas in relation to any of the provisions on external fire spread?
I don't remember, so I'd be very much surprised.
Now, before we move on, we can see that you, in your email to Ken Knight, if we just go back to that, CLG 30 is 19136, you said that giving the NIC, EIC responsibility for approved document P would be a bit like letting Ronnie King write ADB, explaining that it would save the department the costs of drafting, but that it would not necessarily be in the best interests of UK PLC. What did you mean by UK PLC?
That's a phrase people often use to describe the success or otherwise of the national economy.
Industry, in other words.
Well, in its broadest sense, the success of the economy affects all of us.
So just to be clear, is this right, that the interests of the, as you put it, the national economy would not be served by Ronnie King as draftsman because, is this right, that he would have public safety, perhaps in particular sprinklers, in mind as a priority rather than the interests of UK PLC?
Yeah, I mean, the nature of developing any policy, and safety policy is no different, you're balancing the costs and benefits of the different options. If you ignore one of those two balances, you don't have a balanced policy. You have something which one might argue is too expensive.
Yes. I mean, looking at it, was the point you were making in the way you were making it really just saying that it would be undesirable to let somebody who had the absolute priority of fire safety be responsible for writing the approved document on fire safety?
If it was absolute and they never considered cost, yes.
Yes, I see. Would that be the right way round? I mean, given that the provisions of Part B and approved document B are specifically and entirely directed to the protection of life safety and not to the protection of industry or any other economic or commercial interests, what would be wrong with letting somebody, I'm not saying necessarily Ronnie King, but somebody who had life safety as their absolute priority, craft the regulation or craft the approved document?
The country would be bankrupt.
Would it?
We'd all starve to death, ultimately, I suppose, if you took it to its extreme. I'm not sure that would happen in practice. But that's the policy conundrum that governments are faced with, is you need to balance the cost of regulation with its benefits. So
death by fire or death by starvation, and that's for the government to choose between. Is that in its most extreme form?
In its most, I mean, I don't think anyone talked about it in those terms, but that's the principle, and ensuring that finding the right balance is what governments have to try and do.
Yes. And the balance point, would you accept this? The pivot point isn't exactly halfway between the two. It would be somewhere between the two as a matter of judgment based on the best information available.
Yes, and there's a political element to that as well, I guess.
Which is what?
Well, in the case of this particular period of time, the government of the day was concerned about the damage to the economy that had occurred as a result of the financial crisis. And so it was focusing on trying to shift that balance so that industry was freer to improve the economy.
And possibly adopt the slightly lower, slightly weaker standards of fire safety.
If you follow that through, yes.
Did the review of the approved document leading to the 2013 amendments involve any review of the technical standards?
No, that wasn't the terms of reference of the work that we were doing.
Right. And can we agree, therefore, that the review didn't lead to any substantive changes to any aspect of the provisions relating to external fire spread, in particular Section 12?
That's correct.
Yeah. Was any consideration given at all to any amendments to any part of Section 12 during that review?
No, don't think so.
If we go to CLG 100091114, here we can see that in the wake of the Grenfell Tower fire, on the 15th of June 2017, the day after, here's an email, second email down, from Bob Leadsom to you at 15:15 that afternoon. Subject, urgent Grenfell fire, 1 in, 3 out rule, obviously now 2 out, line for media handling by 12:15. Brian, can you remind what was done in 2012 review? Bob, you see that?
Yes.
Now your response is at the top of the chain. We updated a few standard references, gave new guidance on wall coverings to avoid unintended consequences of the EU classification system, gave new guidance on thermoplastic lighting diffusers and roof lights, which provided a significant reduction in regulatory costs. Now, given the date, can we assume, fairly perhaps to you, that this was written in some haste?
Yes.
But it does about sum it up, doesn't it?
Yes.
Yeah. And the changes you refer to in the second and third bullet points related, I think, to internal fire spread, don't they?
Yes, they do.
Yes. And those were, am I right, deregulatory changes?
Absolutely, yes.
In 2012, help me with this, while the approved documents were under review, although at this time through a deregulatory lens, would it have been particularly difficult or time-consuming to have drafted a definition for the term or phrase filler material, etc., in 12.7 and included it in the 2013 edition?
It wouldn't really have been in terms of reference what we were being asked to do. I guess we could have done it.
I mean, given the history we covered yesterday and today of the drafting and the consultation of 12.7, or rather the absence of it, did anybody think, now that we've come round to another round of amendments to ADB, that it might be good and useful to consult on what you didn't consult on last time, and at least ask industry what they thought 12.7 meant, whether they understood filler in the sense you intended it, and in any event, perhaps, as a belt and braces exercise, to include a definition in Appendix E. Did anybody think to do that?
No, it would have been outside what we were being asked to do at the time.
So you were being asked to do. You were the government.
No, I was a civil servant.
All right. I'm not sure that's a distinction I'm making here. You were part of the executive arm of government responsible for the review of ADB, yes?
We were responsible for. We weren't reviewing ADB at the time. We were looking for quick wins to reduce regulatory burden in the building regulations. That's what ministers asked us to do, so that's what we did.
Did nobody think to go to ministers and say, well, look, here's this quite important change we made in 2006. To be honest, it was all a bit late. The timing didn't work. We put some changes in. We think they might need to be clarified. We just want to put an amendment in by way of clarification or by way of a definition. Can we do that? Was that not something that you or perhaps your seniors could have had?
No, I mean that wouldn't have made sense at the time. I mean, there's only so many of us that working on a range of different things, so we were focusing on what we were being asked to do at the time.
I mean, an additional definition in the glossary in Appendix E wouldn't have fallen foul, would it, of any of the deregulatory measures or criteria then in place, would it?
Well, you'd have needed to demonstrate that it didn't add any additional cost, and we would probably have only got it into the process if we could demonstrate that it was reducing cost.
Right. But it wouldn't have added any additional cost, or would it, if all you were doing was spelling out what you'd always intended from 2006?
Well, we'd need an evidence base to demonstrate that one way or another, so that would have been a year's work, and so that wasn't really within the scope of what we were being asked to do.
Oh, well, were you not sure Were you not sure that people at the time were reading 12.7 the way you were, so that there was a risk? They might have been reading it differently, and therefore a risk that it would be expensive to revert to what you meant rather than what...
No, it wasn't something that we gave any consideration to at all. We were asked to find quick wins to reduce regulatory burden, and we identified those things that we knew that we'd be able to do quickly and easily that had a measurable reduction in regulatory burden as it's described.
Did you or anybody else at this time, given what you told us about going back to class naught at the next opportunity, give any thought now, at this point, 2012, 2013, to removing class naught from diagram 40?
If we'd have been thinking about class naught, we would have been considering it in the round in the way it's used throughout approved document B, and we'd be thinking about the entire classification system. I don't think we would have just focused on external wall construction. So again, that would have been a significant piece of work, whereas what we were tasked with doing was finding those things that we could address quickly.
So I think the answer, perhaps put a different way, is you could have done, but it didn't fit the instruction.
Yes, that's the nature of working in the civil services. You get instructed to do something, you get on and do it.
Did you or anyone else, as far as you are aware, give any consideration during the 2012 review to bringing to an end the parallel operation of the national reaction to fire regime and the European fire classifications within the approved documents?
No, I think that's what I just said. Is that would have been out with what we were being asked to do at the time. That's a significant piece of work.
Yes, but what was wrong with suggesting that as a significant piece of work to run alongside the 2013 amendments, given that Class B, the Euro class, had been coming on for 11 years?
In response to this brief, that wasn't something that would have been appropriate, and I imagine would have been rejected.
As at April 2013, when the new edition of ADB was published, do you remember what were the department's plans in respect of bringing to an end the transposition period?
I don't think there were any specific plans at that point. I think it was something that we were aware of was an issue that we needed to consider. It's quite a complex issue. Because the way the European classification system worked, you needed a lot of different standards in place for each product. And so the transposition into the new European system was taking a lot longer than I think anyone expected when it was first introduced. So there wasn't an obvious driver to do that quickly. And as I say, pretty much the plans that had been put together prior to the financial crisis had been put to one side, and the new government had come in, and its focus was revitalise the economy. And one way to do that was to reduce regulation.
Well, now you say in that last answer that this was something that as an issue you needed to consider. As of April 2013, when was that issue going to be considered?
I don't think we had a planned programme of when that would be happened. Clearly, it would be looked at next time we looked at approved document B, insofar as the European fire tests were concerned.
You say clearly it would be looked at the next time we looked at approved document B. Standing as you were in April 2013, when would that have been?
I think honestly we didn't know. As I say, I think the plan, the future of building control report and the response to it that had been produced had something along what you might describe as a work plan for the division as how it would approach building regulations in the future. That had been either put to one side or perhaps thrown away altogether. I'm not quite sure which. And so going forward from that point, we didn't have a plan about how we were going to approach things.
Right. So was the position in government, so far as you could observe it, that the transition period was an eternally enduring state of affairs? Or Or to use Dr. Crowder's word, extended and extended and extended.
I don't think there was a decision one way or the other to delay or move it forwards or backwards. It wasn't a question that arose.
Now, we know, perhaps moving to a different area of some questions I have for you later, but we know that in 2012 you commissioned, and this is before the Lacknall inquest, you commissioned, I think, the 7 work streams project.
Yes.
Not one of those 7 work streams included anything on external fire spread, did it?
No.
Why? Why is that?
So that particular contract, at that time, and I was working on, when was it 2013? So I'd have been working on Part P at the time. And I was conscious that a review, we were expecting at that time I'd start a full review, a technical review of approved document B in fairly soon after that, within the next couple of years. So the idea I had was to try and commission some research that would address some of the more complex issues that could be considered by a contractor that didn't need much intervention from me. So it was what I was trying to do was get ahead of the game, so that when I got to doing the next review of approved document B, we already had some work in hand.
But why not then, given what you told us this morning about Class 0 being reviewed next time round, why wasn't that on the list of 7 work streams, perhaps an 8th work stream?
I didn't think at the time it was something that I needed to do that kind of research on.
But this is, why not, given that all the history we've been through about Class 0, the contrivance as it's been called, we covered that this morning and yesterday, given the views about Class 0 espoused by the BRE and its unreliability for predicting external fire spread, why not make it the subject of research and recommendation ahead of the next ADB at this point, 2012, as part of the 7 work streams project?
I think at that time, the work that I was commissioning was mostly about trying to get some technical work done. There was some economic work done as well. But I think if we were looking at the retiring the BS 476 standards, that wasn't the kind of work that I was looking to do at that stage. It was more this kind of deeper thinking. And as I say, it was a list of things that I came up with, which I thought would get us ahead of the game for the next review. So they were questions that myself and I think Steve Kelly was working with me at the time, we came up with. My expectation would be that once we got to do a full technical review of approved document B, we would commission further research then.
Well, why would you do it that way around? You've got 7 work streams running as research for the next round of ADB that you were expecting to have to do at some point. You knew Class 0 needed to be looked at that point. Why not just add it to the list?
I don't know if I didn't think of it at the time, or if I did think of it, I didn't think it was a good idea, but it wasn't something that crossed my mind at the time as being the kind of work that I could commission that would run with little intervention from me.
Well, you see, it doesn't require, does it, the retiring of BS 476? All it requires, isn't it, is to bring to an end the transition period so that diagram 40 would simply refer to Class B S3 D2.
If all I was if my only job was worrying about diagram 40, that's what I would do. But I was responsible for several approved documents and Part B and all of Part B.
Well, that I understand, but, and I'm not suggesting that your only job was the guardianship or otherwise of Class 0, but we've seen quite a lot of the history of Class 0 in the decade or so before this time, and what it shows. And as part of a preparation for a review of ADB, I just want to understand why it was that coming back to it, given that you knew it was something that had to be addressed, wasn't something within the 7 work streams. But I
didn't think it was necessary at the time. You do have a tendency to conflate the two issues, which is retiring the 476 series, which is Class 0, Class 1 through to 4, and the other classifications associated with 476, and Diagram 40, and those classifications are used throughout the approved document. So it's a bigger question than just external wall construction.
Yes, I'm not suggesting retirement. I'm simply suggesting amendment of Diagram 40 and its concomitant, 12.6.
I think at that time we didn't think that wasn't something that was on our minds as something that needed work.
Very well. Now, can we look back at your witness statement, please? Page 14, paragraph 39. Now, here we can see that you're referring to the period leading up to the formulation of the department's response to the coroner's recommendations in May 2013. And if you look at paragraph 39, last sentence, you say, that's a full technical review of ADB, would have to be set against the government's priorities of the day, which were deregulation and promoting house building. Now, the two deregulatory policies in operation between 2011 and 2013, I think, were the one in, one out policy, which became 1 in, 2 out, and then 1 in, 3 out, and the red tape challenge, including a construction red tape challenge from 2012. Is that right?
I know there was a commitment to reducing regulation on house building as well, but I can't remember when that arrived.
Right. Now, looking at the 1 in, 1 out, is this right, an administrative policy, as you understood it, that operated across government, whereby, in theory, no new regulation could be introduced without a compensating reduction in regulation also being made?
That's right.
And what counted as one regulation for this purpose, as you understood it at the time?
So the way the system works is you monetised the annual cost to business of a provision. So you would work out for a year how much industry had to pay to comply with a particular requirement, and that would be balanced against. So you do that for both provisions, and they'd need to balance out. So you ended up with a net reduction or a net zero.
Right. And was it your understanding throughout that the 1 in, 1 out and 1 in, 2 out policies applied to guidance under the regulations, including the approved documents?
Yes.
Yes. And on what was the basis on which you understood that to be the case?
I'm sure it's something we discussed at various points, but it's it would be a fairly pointless policy if it didn't impact on the technical guidance supporting the building regulations.
Well, that's an argument, but were you ever told it applies, or did you ever read a document or an instruction or a protocol or policy that told you that ADB or any of the approved documents were subject to these policies?
We had a fairly regular interaction with colleagues in the the Department for Business. I can't remember what it was called at the time. And there's a better regulation executive there to the team of officials that deal with regulatory policy.
Right.
So we would have talked to them about it.
Now, regulation was defined. I don't know if you ever looked at the definition of regulation in the guidance. Did you ever do that?
I must have done.
Right. Let's look at it. INQ 301551, page 4. If we go, please, to INQ 30155131. Page 4. There's a heading halfway down your screen. What is in scope of OIOO, 1 in, 1 out? And the answer is this at paragraph 13. The regulation is defined as a rule or guidance with which failure to comply would result in the regulated entity or person coming into conflict with the law or being ineligible for continued funding, grants, and other applied for schemes. Did you read that, or were you familiar with that language at the time?
I think I was, and that to me includes approved documents.
To me, you say, includes approved document. How did you understand that applied to the guidance in approved document B?
Well, approved documents have a statutory basis which is set out in, I think it's Section 7 of the Building Act, and so they're often described as de facto regulation in that whilst it's not a written in a statutory instrument, what you write in an approved document has an impact on the way the industry behaves and what it needs to do, which it clearly does.
Right. As you tell us, I think, in your statement, of course, the approved documents aren't mandatory, are they?
No, their status is set out in Section 7 of the Building Act. Compliance with an approved document is evidence tending to negative liability,
yes.
and the alternative is true if you don't follow them. So in practice, the approved document has an impact on the industry. It has a regulatory impact.
So did it come to this, that you understood the expression failure to comply would result in the regulated entity or person coming into conflict with the law as including becoming subject to a negative presumption of compliance?
Yes, I mean, this isn't a new thing. I mean, we'd been working with better regulation policy all the time I'd been working in the department, and we'd always, and the content of the approved documents was always included in that.
Can I take it that you, at least, to your knowledge, to your knowledge, the department never took any legal advice about whether approved document B was subject to the one in, one out regulation or policy?
You wouldn't take legal advice because it's not statutory, is it? This is government policy. So you'd discuss it with the policy team, and the policy team would have confirmed that they expected the approved documents to be covered.
And did you have such a discussion with the policy team?
I don't remember for sure, but I thought we probably did.
Can we look at your statement, please, at page 87, and within that page, paragraph 235, and you say this. On 16th July 2013, Secretary of State Eric Pickles wrote to Nick Clegg MP and Vince Cable MP, seeking clearance from the Home Affairs Committee and the Economic Affairs Reducing Regulation Subcommittee to consult publicly on the results of the recent review of building regulations and housing standards. The pro forma for the request was included. I note that the Secretary of State includes a line in his letter that housing standards are not within the scope of the one in, two out system. I'm not able to say what the Secretary of State meant by housing standards, but as I have set out above, it was my understanding that building regulations were within the scope of one in, two out system. Now, let's go to the letter that you refer to there. You can see it's CLG 30192227. You can see you refer to it there. If you go to that, you can see the date on page 1, 16th of July 2013. And if we scroll down to page, it's to Vince Cable and Nick Clegg, not in that order. And if you go down, please, to page 3, and the third paragraph up from the bottom of the page, you can see that Eric Pickles says this is a red tape challenge measure, and I'm advised that housing standards are not within the scope of the one in, two out system. But despite that, my department has prepared an impact assessment which I attach and intend to publish. Now, bearing in mind that this letter sought clearance for a public consultation on the recent review of the building regulations and housing standards, do you know which officials would have drafted this letter or advised on whether or not housing standards did fall within the one in, one out measures?
Probably Richard, Harrell, might have been somebody in the planning directorate as well.
Right. What about you?
No.
The subject of the letter, which I'm afraid I omitted to show you at page 1, but I can tell you, is rationalisation of the framework of building regulations. You wouldn't have had a hand in this letter?
I don't think so. I mean, I was involved in the housing standards review, but
right.
Not in its sort of leadership, if you like.
Did you see this letter at the time, do you think?
I might have done.
Was there a question mark in your mind about what was meant by housing standards?
I'm thinking about the context of this letter. It's probably talking about those standards that local authority imposed on house builders through the planning system, and a big part of the housing standards review was to try and reduce the impact of those wherever possible. And I think they weren't included in the one in, two out system because of the way the planning system worked.
Right. Did anybody in your department seek advice about whether or not the building regulations which of course are the subject of this letter, as well as housing standards, were within the scope of the one in, one out policy?
I think it was very clear to us that it was included in the one in, two out policy.
Clear to you from what?
From its inception.
No, but from what evidence, from what advice?
I can't recall at the time, but it was fundamental to the work we were doing.
Did you or anyone else in the department, to the best of your recollection, consider applying for an exemption for the building regulations from the one in, one out, and later one in, two out, and three out policies?
I don't think we'd have been able to justify that.
Why is that?
It's a important piece of regulation. Government was trying to reduce regulation.
Right. So you basically wave the white flag before entering the battlefield.
It's not civil servants' job to confront the government policy. It's their job to implement it.
Is it not also a civil servant's job to advise government on what's safe?
Where appropriate, yes.
And was this not an example?
I don't think so. It was clear the government was trying to reduce regulatory burden. We didn't set out, none of the things we did, in my view, reduced the level of safety, but they reduced the cost of regulation.
Now, the red tape challenge, that was just correct me if I'm wrong, Mr. Martin, that was a cross-government policy designed to crowdsource views from industry, businesses, organisations and the public about which existing regulations in the stock of existing regulations should be improved, kept or scrapped, yes?
Yes.
And after that, the Government and Cabinet Office would identify areas of work to deregulate.
Yeah, it was an enormous cross-government project.
Yes, and that was in operation between 2011 and 2014, or 15 perhaps.
That right? Sounds about right. I can't remember.
Were you aware that the RRO, the Regulatory Reform Fire Safety Order 2005, was expressly excluded from that process by ministers in 2012?
Yes, it was exempted from the red tape challenge. I think one of the arguments they had is that they'd only recently completed a review of the enforcement processes, and so the point they were making is there was nothing left to achieve from reviewing it again.
Right. Did you understand it to be exempt on the basis that it was an essential life safety measure, or because it was part of some earlier deregulatory drive?
I think the main argument was that it had already been subjected to an exercise, and things like one in, one out, and so on would only really arise if there were proposals to change the provisions in some way, which there weren't.
But that is great. It's very circular. It was exempted from the red tape challenge, which meant that if there were changes which were needed, they could happen.
No.
Is that wrong?
No, I think they're two separate things.
Right. I see. Did you or anyone else in the department consider applying for an exemption for the building regulations from the red tape challenge process?
No.
And why not?
I don't think it would have been. We didn't really have a strong argument for doing so.
Well, how about life safety being a strong argument for doing so?
Well, building regulations covers a wide range of different things. In terms of the red tape challenge, it was looking to reduce unnecessary, what I think the government would have considered unnecessary burden. So arguably, if there was a provision which was going to be reduced, which would have a negative impact on safety, then I think the government wouldn't have supported that.
We're going to turn to something different now, but we're going to stay more or less where we are in the chronology. And we are in the chronology in 2013. And I want to come back to the topic we were on before, which is 12.6 and 12.7 of ADB. And this is a topic we are now going to be on, covering a number of years for the next few days of your evidence, if that's all right with you, Mr. Martin. In your statement, if we can go to that, please, at page 54, you say this at paragraph 155. You say this: there were certainly concerns raised about the testing of cladding products, including ACM panels and insulation materials, during the period 2009 to the 14th of June 2017, and I was aware, as were senior officials within the department, of the issues regarding the testing of such products. However, within the context of the system of building regulations in England, it was my view that relevant industry bodies were taking appropriate steps to produce guidance and ensure that the functional requirements of the regulations, particularly requirement B4, were being met. Where I was able to, I tried to assist the industry during the period in question, drawing on my knowledge from both my time in the department and at BRE previously. Now, looking at what you say in line 1 of that paragraph, what were the concerns specifically that were raised about the testing of cladding products in that period?
I think I've picked that particular period because that's the question that the inquiry had asked me. I think following the 2006 amendments, it probably wasn't until I'd been contacted by, it wasn't until something like 2013, 2014, before questions were being raised with me about how that guidance should be applied.
Well, what were the concerns that you say were certainly raised about the testing of cladding products in that period, including testing of ACM panels and insulation materials?
In preparing for giving evidence, I've looked back over various documents, and I think it was either 2013 or 2014 that BRE contacted me and had a question about how to apply whether something was a filler or not in terms of...
We'll come to that. Yeah, we'll come to that. That's November 2013, Tony Baker at the BRE and his question,
yes,
which we'll come to. But I'm just interested in the period 2009 to the date of the Grenfell Tower fire. That's that 8-year period. You say there were certainly concerns raised about the testing of cladding products, including ACM panels and insulation materials. And I just wanted to know what those were. What were those concerns about the testing?
I'm using testing in a very general way, I think, in this point here, and I think, as I say, the first one I'm aware of is the email from Tony Baker.
Well, okay, let's not exactly jump from the line, does it? Because that starts in 2013. What was it? What happened then during the period 2009 to November 2013, by way of concern about the testing of cladding products?
As I recall, very little. It wasn't an issue that came across my desk particularly.
Right.
During that period, I was focused on other reviews. I think when I joined the department, I was working on a review of Part J of the regulations, and as we were just discussing, I then moved on to doing some work on Part P and the Housing Standards Review and the Red Tape Challenge. So that swallowed up quite a lot of that time. And up until about 2013, I didn't really come across the issue of the application of Section 12 of the approved document as being an issue.
And you go on to say, and I was aware, as were senior officials within the department, of the issues regarding the testing of such products. Well, what issues were senior officials in the department aware of during the period 2009 to the 14th of June 2017 on that topic?
I mean, this paragraph is a summary of other things that are in my statement. I think what I'm referring to here is when, following a meeting in 2014, I'd contacted the NHBC. They'd reported that they'd been approving buildings on the basis of a Agremont certificate, which had subsequently changed, and they were concerned that that meant that decisions they'd made in the past might not be right, and I brought that to the attention of Richard Harrell and Bob Ledson. I
see. These are all matters that occurred, which we will look at in detail after November 2013, aren't they?
Yes. So prior to that, I didn't. The question of external wall construction was not something that was prominent in my work.
Right. Now, when you refer there to relevant industry bodies taking appropriate steps to produce guidance, what are you referring to there?
NHBC, the Building Control Alliance, and CWCT.
And do you count all those pieces of guidance as appropriate steps? You count those, do you, as amongst the appropriate steps relevant to B4?
Yes.
Now, you may know that NHBC regarded the BCA guidance as guidance only for their customers, or only for only for Building Control Alliance customers. Did you see it the same way? The BCA readership was limited to the members?
Building Control Alliance is all approved inspectors and all local authorities, so that's all regulated building work, isn't it?
It's building control, yeah, not designers though.
You just said BCA customers. I mean, the customers would, I think, well, certainly NHBC would regard their customers as being the builders.
Yeah, oh, I see. All right. Now, as far as you're aware, before issue 0, which is the first issue of BCA Technical Guidance Note 18 in June 2014, other than the two pieces of CWCT guidance, that's the 2008 standard and Technical Note 73 from March 2011, was there any other industry guidance on complying with the functional requirements of B4 issued by industry bodies?
I know that there were changes to British Standard 9999 and 9991. I think they would have been post-2015, though.
They were in 2015. But leaving all that on one side, was there any industry guidance before BCA Technical Guidance Note 18 issue 0 in June 2014, other than the two CWCT documents?
Not that I'm aware of.
Now, in your statement here on the screen, you say that it was your view that, quote, relevant industry bodies were taking appropriate steps to produce guidance, and then you say, and ensure that the functional requirements of the regulations, particularly requirement B4, were being met. What were those steps? What were the steps that they were taking?
I guess I'm principally thinking about the guidance, but certainly I recall NHBC carrying out a review of the projects that they dealt with to ensure that they were getting it right.
Did you, during the period 2009 to the date of the Grenfell Tower fire, think that it was the responsibility of industry bodies, such as the NHBC or the BCA or the CWCT, to take steps to ensure that the functional requirements of B4 were being understood and met?
I think that partnership between the department and industry bodies has been something that's long established. The department relied on that.
And what was the basis for your thinking that responsibility fell to industry organisations?
Most of those industry organisations, that's one of their sort of reasons they're established, is to promote good practice in their sector.
Did it occur to you that if industry bodies had to produce their own guidance, or guidance about the guidance, there was something wrong with ADB, which was, of course, itself the official government guidance?
No, I think that's something that was quite common right across the building regulations.
Well, what did you think was the point of guidance about guidance?
Construction is a very complex subject. The approved documents tended to set out high-level guidance, but different sectors of industry would produce standards or trade body guidance to try and help their members address the issues that were specific to their particular activity. If you group that all into a single document, it would be enormous.
Well, the particular activity, taking building control, being a pretty broad activity, did you not think that if industry had to interpret or explain your guidance, industry, for example, being building control, there might be something wrong with it?
No, I mean, that's something that had been happening all the time I'd worked in building control. There'd always been, right back from when I first started working as a building control officer, there were documents produced by what was then the District Surveyors Association, which helped building control officers interpret the building regulations.
But wasn't it let's help me with this, wasn't it the government's responsibility, indeed, in the end, your responsibility, Mr. Martin, to make sure that the public, picking up ADB for whatever reason, understood exactly what was required in order to follow the government's official statutory guidance, rather than leaving it to industry or particular sections of it to interpret and articulate the government's intention by producing guidance about the guidance?
I can see why somebody might desire that, but that was never the case all the time I've ever worked in building regulations. There's always been industry guidance that supplemented the building regulations guidance.
Well, you say there always has been. In fact, isn't it right that until issue naught of technical guidance note 18 in June 2014, the BCA and NHBC had got on perfectly well without it?
I'm talking generically. As I say, since I joined building control, there's always been industry guides that we've used to supplement the building regulations on a wide range of subjects. So the idea that a trade body is producing some more guidance isn't in of itself a problem.
Did you consider that it was government's job to ensure that those using the guidance in ADB understood what the government intended by its provisions?
My view is that we needed, and something that I'd been working on at various points during that period, we needed to try and improve the quality of the approved documents. That was something that I think was an opinion that Mr. Harrell and I certainly shared, is that, which is why we progressively developed the new house style for approved documents to try and improve the quality of the guidance we gave, and the work we did on with plain English editors and so on was intended to try and improve the quality of that. But I think whatever we'd have done, there would have always been supplemental guidance produced by trade bodies.
Did the department in any way rely on the guidance produced by industry itself during that period?
I'm not sure if I understand the question. Can you rephrase it?
Yes. I mean, you referred earlier to a partnership between the department and these industry bodies. I mean, to what extent did the department rely on these industry bodies to produce guidance which clarified or supplemented or answered questions which had been left behind by the guidance that your department produced?
I think that was kind of a bread and butter part of the work that we did.
Why would it need to be? Why would the statutory guidance be so unclear or imperfect or incomplete that you had to rely on industry bodies' guidance about the guidance to fill in the gaps?
I guess there's a number of factors to do with that. One is that we didn't review the approved documents as often as perhaps I think we should have done. But that was a matter of available resource and the way that the system was structured. And it's nigh on impossible to try and write a book that tells you everything you need to know about constructing a building properly. It's an incredibly complex subject matter.
Did you consider that guidance produced by industry in some way discharged the department's obligation or responsibility to update and amend the guidance in the approved document, particularly when it became clear that it was unclear in any respect?
If you're talking specifically about the Building Control Alliance guidance in relation to external wall construction, then I think to some extent I saw that as a short-term solution to a problem that had arisen.
Well, we're going to come back to that, but I'm not talking about that. I'm talking in broad terms. Did you consider that the guidance produced by industry at any time in some way discharged the department's responsibility to update and amend the guidance in in any approved document?
I'm not sure I ever thought about it in those terms. I think it was a normal part of our work as policy leads to try and work with the different industry bodies to help their members achieve the outcomes that the regulations were designed to achieve.
I mean, to what extent did you rely in your own mind upon these organisations, as it were, coming to the department's rescue, so that where you perceived that there might be a gap or a lack of clarity in a particular provision, you could rely on those industry bodies to put it right?
I suppose a way of approaching that question is to say what would have happened if none of them did, and I think there would have been a really big problem, bigger than the one we're dealing with now. So I guess the answer to your question is yes, the department did rely on industry bodies to help in achieving the objectives of the regulations. And
would it be fair to say that you, in the period 2008, from when you became full-time at the department until the date of the Grenfell Tower fire, considered that the organisations producing guidance, so CWCT, NHBC, the BCA, Booth Murie, were reputable, reliable and reputable organisations?
Certainly the trade bodies I worked with, yes.
Yeah. And would you expect, or would you have expected, that the guidance issued by those organisations would have been written by knowledgeable and experienced professionals.
Yes, often I'd expect most of them to be more knowledgeable about that specific subject than I was.
And as the government's principal construction professional from 2008 with responsibility for approved document B, did you ensure that you read or reviewed all such guidance?
I don't think that would have been possible. I reviewed the guidance if it was brought to my attention. Very often the various trade bodies would contact us and talk about work that they were planning to do, and we'd discuss, try to influence them in a way so that it would be effective in delivering the objectives of the regulations.
But that would depend upon them sending it to you and asking for your views. Was there a system within the department to make sure that you kept tabs on what publications they were intending to put out, which gave guidance about the guidance?
No.
Why is that?
Well, there was. I'm not responsible for setting up systems for the management of the entire regulatory system, but I don't think it would have been practical to do so anyway. It would have been very resource hungry.
Well, it depends. How many of these trade bodies are there that would produce guidance? We've counted NHBC, BCA, CWCT. Are there any others?
For each functional requirement, there's probably dozens.
Right. I'm thinking about fire safety particularly.
Yeah, well, I didn't have that luxury. I was working on anything up to 4 or 5 different parts of the regulations at different points in my time.
Did you consider that there was any role for you or for the department in general in checking industry guidance, checking it was accurate?
I think we'd always have to be careful in that we very often couldn't actually endorse a particular piece of guidance, so we didn't have we would try and contribute helpfully, but the position would be is that each body would be responsible for the guidance that it produced for its members. So we would try and help and contribute, sometimes facilitate where, I certainly remember in the past where a body would say, we're thinking about looking at this subject, and I might say to them, actually, so is another organisation. You might want to talk to each other. So we try and facilitate that, but we didn't have the time or resources to be directly involved in all of it.
You say you couldn't endorse a particular piece of guidance. What about the opposite? What about condemning a piece of guidance?
I don't recall that issue ever arising. We wouldn't have had a mechanism to do that, so that would have been quite difficult to do.
And what if, for example, a trade organisation produced a piece of guidance that not only plainly misunderstood a provision in approved document B to do with fire safety, but proposed a way of complying with approved document B that was plainly and obviously downright dangerous? What would have happened? Would the department have just let it lie, or would you have intervened?
I think we'd have tried to intervene in some way, but we wouldn't have had any direct statutory power to do so.
Did you, during this period, 2008 to the 14th of June 2017, understand guidance issued by industry to have the same status and authority as the guidance issued by the department in the approved documents?
No, it wouldn't have the same status as an approved document. That's set out in the Building Act.
Right. So they had a lower status, did they?
I guess so. I think when courts look at these things, they often look at what's best practice in the industry at the time, and so they would look at that kind of thing. So it would have some legal status, I suppose. That's not an area of law I'm an expert in.
Did you at the time understand the guidance issued by these various industry bodies to have the same breadth, the same reach in terms of audience or readership as the guidance issued by government?
I think a lot of it would do. Certainly, where some of it would be targeted at people that worked in a particular sector, and to some extent might have had a better reach because it would have been drafted in terms that they were more familiar with, and it would have been drafted with that particular sector in mind.
And looking at the last sentence of paragraph 155 of your statement, you say there, where I was able to, I tried to assist the industry. In what circumstances were you not able to assist the industry?
There was only one of me. I couldn't be at all of the meetings all of the time. Certainly there were times when I think the drafting of BS 9991. I missed a lot of the meetings because they clashed with whatever else I was working on at the time. So I didn't go to as many of those meetings as I would have preferred.
Now let's go to January 13 and Mr. Turner again, Ipswich Borough Council. Can we please go to CLG 30191993? We looked at some correspondence that you had with him in the June of 2013. This is earlier in the year, January 2013. And if you go to page 2, we can see an email from Daniel Turner to you at 3:11 in the afternoon on the 21st of January 2013. Now, it's not in very big print, but we can, I think, yes. Dear Brian, you see that?
Yes.
My email system is advising me that your email address is no longer valid, etc. That's how it starts. And then it goes on. We're currently working on a multi-block, multi-storey housing development ranging from a 6 to 10-storey concrete and timber frame blocks. The architect and contractor are proposing to utilise Kingspan's SIPs, which are effectively a section of PIR insulation sandwiched between two sheets of OSB. We've assessed all of the unprotected areas, etc., with the architect, and due to the high degree of compartmentation, they can effectively have 100% unprotected areas. The SIP's panels are to be clad internally with plasterboard and externally with different cladding materials such as brick, rain screen cladding and possibly render. However, a query has been raised by Kingspan in that they are unable to prove that their SIP's panels meet with the provisions of paragraphs 12.5 to 12.7 of ADB Volume 2 and BS 8414 Part 1 2002 or BS 8414 Part 2 2005, as they are not formed from materials of limited combustibility. This is the first time we've utilised these panels on developments over 18 metres, and we are unsure as to whether this paragraph is applicable to this type of construction or if it was intended for an alternative system, such as where a thin coat render is placed directly onto insulation which is fixed to the frame. Presumably, if this paragraph is applicable to SIP's panels, then this would prohibit their use in this instance, unless a manufacturer can produce one which is of limited combustibility. And if we go up to page 1, I've read all that to you because it contains quite a lot, but if we go to page 1, you can see your response at 15:31 on the same day, so exactly 20 minutes later, and you write as follows. Hi Daniel, I'm still here, or at least I think I am. I'll get back to you on this. Are the panels just infill or are they structural? Why did you ask him that question?
I think he's talking about SIPs, which are often used as a structural panel as well as an infill. So I think I was just trying to get a better understanding of the construction he was.
And SIP stands for what?
I think it's structural insulated panels, but they're not always used structurally.
Right. What difference would the answer to the question have made as to whether or not the panels would comply with the guidance in approved document B, particularly the paragraphs he's referring to?
I'm not sure it's relevant to the paragraphs he's referring to, but perhaps I was trying to get a better understanding of the building.
Right. Why did you need to, as you put it, get back to him? Was the answer to his question not immediately obvious to you?
I was probably busy doing something else.
Right, I see. Now, in January 2013, were insulating panels with a PIR, polyisocyanurate core, permitted for use over 18 metres by the provisions of ADB, or were they not?
It's an insulation that's not a material of limited combustibility, so I think the answer is no.
The answer is no, isn't it?
Yes.
Yes. And was that not the obvious answer to the question by reference to 12.7, which he had actually raised?
Yes, I think so.
Why didn't you simply tell him that?
As I say, I was probably busy doing something else. It looks like I've responded quite quickly. Might even have been using a mobile telephone or something. I might have been out of the office.
Let's move on up the chain. He comes back to you a little bit later that afternoon, 10 minutes later. Hi, Brian, glad to see you're still with us. He says, the panels are only for infill between the concrete frame and I believe the same is going to occur on the timber frame. They will provide support to the external cladding system, i.e. brick ties or angle sections, to support the rain screen in conjunction with the structural frame. Look forward to your response. It's causing us a few headaches at the moment. And you see that?
Yes.
Again, just how is the information that he provided to you relevant to any answer that you might provide to the question he'd asked?
I'm not sure it is. Looking at it, I can't see why I needed to know whether they were structural or not, but
No.
I obviously had something in my mind at the time.
Right, and if we go to the next email up in the chain, we can see that you forward it to Stephen Kelly about 12 minutes later, the same afternoon, with one word, thoughts, question mark. Now, in January 2013, I think, is this right, Steve Kelly was your junior assistant?
I was his line manager. We had a broad work programme. He was responsible for some things directly. So assistant's probably a strong term.
All right. But you were his boss?
Yes.
Yeah. And does that tell us that he was younger than you?
I think he was, but he was newer in the job, yeah.
Newer in the job will do. Why were you asking Steve Kelly for his thoughts?
I was probably getting him to draft a reply, I guess.
Well, you don't say that. You say thoughts, which is you're asking him for what he thinks, no? Not, can you please draft a reply? I haven't got time.
That might be what I meant. It's a single word message, so it might well be that I was using a mobile telephone.
But were you not able to answer this question without asking Steve Kelly for his thoughts?
I would have been able to answer it. I probably wanted Steve to do it so that I could do something else.
If we look up the chain, because it continues, he comes back to you a few minutes later and says, I'll have a little look and chat tomorrow afternoon or something, question mark. And then you, at the top of the chain a few minutes after that, say, cool beans, the AD needs to be read 2 or 3 times to work out what it means. What did you mean by that?
I think, as with all of this guidance, you need to read it carefully.
Well, you had, a few minutes ago, given me an answer, which is that 12.7 basically required the insulation to be of limited combustibility, so it couldn't be used. Why was it necessary to read the approved document 2 or 3 times to know that?
I think it's fair to say over the last 4 years I've been looking at that paragraph almost every day. At that time we'd have been working on a wide range of different things.
Does that tell us that at the time, if you'd simply got ADB off the shelf and looked at it, you would not easily have been able to work out a clear and simple answer, as this email, I would suggest to you, suggests?
I think you'd want to read it just to make, because a building control officer's asking you a question, so they've clearly read it, and you'd want to give a considered reply.
Yes. I mean, it appear in January 2013 that paragraphs 12.5 to 12.7 of the approved document needed to be read 2 or 3 times for their meaning to become apparent, even though you'd written them.
Well, I'm saying that to Mr. Kelly, because it's good practice to be careful when you're reading and writing these things.
Why is it that these provisions had to be read 2 or 3 times to answer what appears, with great respect, to be an extremely straightforward question about whether or not combustible sandwich panels with a PIR core could be used in the external wall construction over 18 metres?
I honestly can't remember what was going through my mind at the time. We'd get quite a lot of queries like this on a wide range of subjects, and it's probably just a throwaway comment.
Well, did it not alarm you that a provision that you had drafted and had taken care over drafting, as we've seen, late though it was in the day back in 2006, now had to be read 2 or 3 times to produce a clear answer? And a clear answer, moreover, to a question raised by an area building control surveyor in a local authority.
I think that tended to apply to nearly every aspect of the building regulation, so I wouldn't have considered that to be particularly unusual. Each project throws up different questions, and you think you know the guidance off by heart, and you go back and read it again, and you think, actually, I think it means something else. You need to take your time over these things.
Well, that's hopeless, isn't it? This is an approved document intended to provide clear guidance to people carrying out the work so that they know with precision and clarity what it is that, if they use it, would at least part of the way satisfy, presumptively, the functional requirement. I mean, this isn't the Old Testament. Why does it keep
Well,
having to be
it is a very complex subject, and we're picking. You're focusing on one, a couple of paragraphs. We had several approved, numerous approved documents, numerous queries, thousands of different buildings with different questions arising. So, taking time to have a look and try and give a considered answer to a question from a building control officer seems fine to me. I don't think this wouldn't have been evidence to me that there was something fundamentally wrong with the guidance. It would mean building regulations gets a bit complicated sometimes, which is something I'd been living with most of my career.
Mr. Chairman, is that a convenient moment?
Yes, I think it's time we had a break. I was going to suggest that if you hadn't suggested it yourself. So, Mr. Martin, we'll have a break at that point. We'll come back, please, at 20 to 4. And as before, I have to ask you not to talk to anyone about your evidence or anything to do with it while you're out of the room. All right?
Yes, sir.
Thank you very much. Would you go to the usher then, please?
Yes.
Thank you very much, Mr. Millett. 20 to 4, please. Thank you. Yes, Mr. Millett, if you're ready, would you ask the usher to bring Mr. Martin back in, please?
Yes, Mr. Chairman, thank you. Can we please have Mr. Martin back into the hearing room?
Thank you very much.
Thank you.
All right, Mr. Martin, ready to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Millett, when you're ready.
Thank you. Mr. Martin, I'm now going to come to the email run that you referred to earlier this afternoon in your evidence with Tony Baker of the BRE in November 2013. Can we go please to CLG 1000585? And I'd like to look at page 2 in that email run, please, at the foot of that page. You can see that... Yes, thank you. You can see that this is an email from Tony Baker, BRE, to you, copied to Sarah Colwell and Stephen Howard, both of the BRE, on the 25th of November 2013. Subject, ADB clause 12.6 and 12.7. And I'll read it all to you. Hi, Brian. I hope you're keeping well. I hope you can help with the following. We are seeing an increasing number of inquiries in which we are being asked for our opinion stroke interpretation of diagram 40 and ADB B4 clauses 12.6 and 7 in relation to the build-up of systems using board finishes, and we would like to reach a general understand, that's what it says, so we can respond to all parties in the same way. First bullet point, systems with board type outer layers, the boards are typically 15 to 20 millimetres thick and achieve BS3D2. Second bullet, clause 12.6 guidance references diagram 40 in relation to the classification of the finish, which would be acceptable over 18 metres as being BS3D2. The 12.7 talks about insulation or filler materials which make up the wall being limited combustibility. Third bullet, as the maximum surface finish is not defined, a debate has opened up within the industry as to whether or not the boards can be called the finish or the filler. Based on our experience from the original PII programme, we would suggest that the definition of the surface finish thickness and, quotes, filler, unquotes, would assist in clarifying this point and would be therefore grateful for your thoughts. Now, had you previously been aware that the BRE was receiving inquiries on this subject?
No.
So did this come as a surprise to you?
Well, it was new to me, yes.
News? Surprising news?
As I say, questions arise about the application of the regulations all the time, so it wouldn't have been surprising that people in the industry were debating what a piece of the regulations may or may not mean.
Maybe, but we're talking about the very provisions that you examined in detail and reconstructed and drafted yourself in November and December 2006. Did it come as a surprise to you that here were quarters of the industry filtering through to BRE a question about what they meant?
Well, I'd been involved in drafting all to some extent all of that approved document and several others by that point, so queries about them was not an unusual thing. But this was the first time somebody had raised a question about 12.6 to me at that time. Do
you know from whom those inquiries had emanated?
No.
Did you ask?
No.
Why not?
I don't think I saw the need to.
Now, if we go to the top of page 2, to the next email in the same chain, page 1, your response, we can see, which is sent just over half an hour later at 15:47. Hi, Tony. I see where you're coming from. The problem we have with Class B is that you can have a thin surface that gives you the performance and back it with something less desirable. So there's no such thing as a Class B material, quotes unquote. The word filler was introduced because of a particular incident where a polymeric foam was used to keep an aluminium panel stiff. The foam was not used for thermal reasons, so it wasn't, quotes, insulation, close quotes. It still burned, of course, exclamation marks. Sarah will remember the details, I'm sure. I'm thinking out loud here, but I think a homogeneous Class B board would be fine, effectively a Class B material, question mark. But a lamination of board with something else should revert to the limited combustibility criteria. Does this make sense? Don't quote me on this yet. What do you think, Brian? Now, first, it looks as if this exchange was the first time Tony Baker's question had been raised with you. Is that correct?
Yes.
And here was a serious question, would you accept, posed by a senior and reputable BRE technician, copied to Sarah Colwell herself. Do you accept that?
Yes.
Yeah. Now, your response half an hour later, as we can see, I've read to you, tends to suggest, and is this right, that you'd never actually thought about this question before? Is that right?
Perhaps not in the terms that was being talked about here.
Well, why is that?
Well, I hadn't been asked this question since we worked on the draft in 2006.
Well, historically, I see why you say that, but given that the whole purpose of adding the phrase filler material, etc., to 12.7 back in 2006 was to ensure that the core of a composite external panel was of limited combustibility, how could you not have thought of this question before November 2013?
Well, I probably hadn't thought about it between 2006 and 2013, which is quite a long period of time. And I think our focus when we were drafting the 2006 edition was thinking about the response to the edge, whereas this was looking more at thinner laminates, which perhaps wasn't at the forefront of our minds when we were drafting that text. But goes back to the point that there are lots of different ways of doing things, and we were trying to draft something with a broader impact.
Well, taking it in stages, did you consider Tony Baker's question carefully and thoroughly and do any research before you responded?
I think that's why I've said, I've asked them what they think of that advice, is because I've responded quite quickly and said, well, this is my thinking based on what I remember of what we did in 2006. And I think I'm referring to the Edge fire there, which Dr. Colwell would have been involved in. And I'm asking them to comment on what I'm saying.
Do we take it that you didn't ask any departmental colleagues about this question before you responded?
I doubt it.
Why did you reply in terms which required you to think out loud and ask your own questions, does this make sense, when you were asked an important question about fire safety?
Because I'm trying to work collaboratively with the people at BRE and say, is this they were looking for something that they could make use of when they were talking to their clients. So the question was, can I help them find a form of words that would answer their questions in a helpful way? So I'm, is this helping them? Is the question? Does it resolve the problem that they're experiencing?
I mean, this is a response sent, which is highly conditional, full of questions. Some 30 minutes after the question, it looks like a knee-jerk response. Would you agree with that? Off the cuff.
Yeah, it looks like it's off the cuff.
Yeah.
I probably wouldn't have replied like that to another organisation, but I knew the people at BRE reasonably well, so I felt I could have a more open discussion with them.
Now, I mean, you I think have just confirmed that the particular incident was the Edge fire, yes?
I believe so, yeah.
Yes.
I can't think of one that would have met that description other than that.
Yes, and you told us before that the word filler was introduced in order to ensure that the core of a composite external rain screen panel was comprised of material of limited combustibility, and indeed that much else in the external cladding build-up also. Why not just say that?
I think that's what I am saying.
Well, you're not, are you?
Perhaps I don't understand the point you're making.
Well, let's see what you say in your statement. If you go, please, to page 39, paragraph 116. you say there, at the start of the paragraph, you summarise the email, and then you go on halfway through the paragraph to say this. He stated that the BRE would like to achieve a general understanding so that they could respond to all parties in the same way, which is a goal that I wholeheartedly supported. I responded the same day, giving an initial caveated view that a homogeneous Class B board, essentially as a Class B material, I posited would be fine, whilst anything else would revert to the limited combustibility criteria. In Mr. Baker's response on 3rd December 2013, he had stated that based on the evidence he had seen, it would, etc., etc. And we'll come to that response later. My question is on this part of the paragraph, where you say an initial caveated view that a homogeneous Class B board, essentially as a Class B material, I posited would be fine. And for what reason were you positing or thinking out loud or giving an initial view on the actual meaning and practical application of a piece of government guidance of which you were the principal author, published more than 6 years before?
I think because they were considering this question about where the finish starts and finishes, which isn't something that had been defined anywhere, and so I was thinking about the products that they were looking at and trying to think, well, how do you differentiate between the two? And I took the view that if it's a continuous homogeneous material in a sheet, then you could regard all of that as the surface. But if you had something below the surface that was different, then material of limited combustibility would be more appropriate. So it just seemed to me to be a reasonable interpretation in answer to the specific question they'd made.
Well, it may have occurred to you to be a reasonable interpretation, but you were the author of 12.7 and 12.6 and 12.7 at the time, and you were, is this right, in authoring it, carrying out the Secretary of State's intention? Yes? That's the point of it.
We jointly authored it. It wasn't me on my own.
Well, we've seen what happened.
Yeah.
All right, you and Mr. Bird, let's leave it at that. Now, do you agree that in doing that, you were carrying out the intention of the Secretary of State? This is the Secretary of State statutory guidance, and you were carrying out his intention?
Yes, I suppose.
Yes. And when doing that, I thought you told us this morning that you had intended to ensure that the core of a composite rain screen panel was a material of limited combustibility, but that the surface was not intended to be a material of limited combustibility, but rested at Class 0, or
yes.
Class B, S3, D2.
Yes.
Yes. And therefore, why not simply say so?
Because I think the question they're asking here is, where does the surface start and finish?
Was that not a question you asked yourself at the time?
In 2006?
Yes.
I guess not.
Why is that?
Didn't occur to us at the time, I suppose. So as I think I've said on numerous occasions, we drafted that perhaps more quickly than we'd have liked to have done, and we weren't able to discuss it with as many people as we'd have liked to have done either.
So is this right? This is the first time that this question had occurred to you or been posed to you or crossed your mind?
Yes.
Well, I was reaching a general understanding as to the meaning of your own guidance, a goal, as you put it, some 6 years after it had been published.
Well, things change over time, so they weren't reporting problems in the years previous to that, so I'm guessing this was becoming an issue they were coming across, so it makes sense to try and help them come up with an answer that made sense and delivered the objectives of the regulations.
Well, you say come up with an answer that made sense. What about coming up with an answer that reflected the intentions of the Secretary of State as you understood them in 2006?
I think it's the same thing.
What is it? It depends. Were you not immediately troubled by the fact that there was a lack of what is called general understanding of your own guidance, your and Mr. Bird's guidance?
Again, as I've said several times, people asking questions about the guidance in the approved documents was commonplace, something we dealt with on a number of occasions every day.
Did you not have thoughts at the time along the lines of thinking that perhaps had you consulted on the meaning of the words filler material, etc., these questions wouldn't have been asked.
I think in 2006 I wasn't entirely happy with the position that we found ourselves in. So I suppose the answer to your question is yes. I'd always thought that I would have preferred to have addressed that in more detail at the time.
I mean, looking at it candidly, Mr. Martin, was this not the chickens coming home to roost?
I didn't see like it at the time. As I say, used to get lots of questions about lots of different aspects of the building regulations. I didn't see this as being unusual.
Now, we don't need to see it, but I think you have elsewhere described the BRE as highly reputable, and can we take it that both Tony Baker and Sarah Colwell were, in your view at the time, experts in fire?
Certainly experts in fire testing, yes.
Right. Did it not trouble you at the time that an understanding of the guidance in 12.6 and 12.7 of approved document B had not already been reached even by the experts within that expert organisation?
Judging by the email, it was an issue that had only arisen fairly recently with them. I guess from their point of view, they're testers, not appliers of the regulations, and they wanted to confirm their understanding.
See, the amendment to ADB, particularly 12.6 and 12.7, had been carried out by the BRE under a contract with the government. Yes?
Yes.
In which you had been involved as an employee of BRE, but also 2 days a week to 3 days a week in government.
Yes.
Did it not bother you that the client who had, that the person who had actually carried out the amendments under a contract, namely the BRE, were asking government about what the product of that contract meant?
No, because it's about the people, not the organisation, isn't it? BRE doesn't. I mean, I'd left BRE, so what I remembered obviously wasn't in anybody else's mind but mine.
Did it not trouble you that Sarah Colwell was asking this question, or rather that Tony Baker was asking this question?
No.
Did it occur to you at that stage that a lack of general understanding, even within the BRE, might at least have led to the emergence of non-compliant practices in industry during the 6.5 or 7 perhaps years since the publication of amended approved document B in 2007?
No, I didn't see that as being a major problem at the time. As I say, we weren't entirely happy with the way that we'd had to draft that text back in 2006, and the intent was to try and get people to think broadly, and to some extent the discussions that BRE were having with their clients was exactly the discussions that we wanted people to have. Was, in the case of this particular product, should I be thinking about the core material or the lining or whatever it is, and what, should we be applying the material limited combustibility rule to it?
So, just so I understand that last answer, when you got this question from Tony Baker, did you think, oh, good, ADB is having an effect, people are starting to ask questions about it?
I'm not sure exactly what I was thinking at the time, but I don't remember it being a particularly big deal to me. It was, as I say, one of dozens of questions that I would have been dealing with.
I mean, the reason I ask is it seems from that answer and a number of others, and please correct me if I've got the impression wrong, that you regarded ADB as really a sort of discussion document, something to provoke debate, thoughts, perhaps more research, interest, rather than being a guide on how to comply with the functional requirement.
I think it sits somewhere twixt the two.
Really?
Yes, I think. As I think I've said a few times, what everybody should be focusing on is on the functional requirement, looking at the guidance, and then applying their judgment as to what they think's right in the circumstances of the building they're looking at.
What's the point of the guidance then?
To help them make those judgments.
Well, how does it help them make those judgments if all it does is provoke discussions, debate, questions, and possibly...
That's how people make judgments, is by considering them, looking at the available information. If they're not sure, going off and doing more research, speaking to their colleagues.
But if I want to comply with the functional requirement and I don't know what to do, what do I look at?
You'd start with approved document B, I guess. You might also look at trade information. You might speak to your colleagues, and if you don't understand it, you'd seek further advice.
And do you think that was the intention and effect of the statutory guidance, Mr. Martin?
To some extent, I think, yes.
How much of an extent?
I think it varies on the project and the complexity of the question you're looking at.
So was it your understanding, let me be clear about this, that the approved documents and approved document B in particular was really just a discussion document to provoke discussion, to allow people to come to a judgment somewhere down the line, as opposed to a strict roadmap which had a presumptive effect of compliance if you complied, and a presumptive effect of non-compliance with all that entailed if you didn't?
I think depending on the situation, there was always an element of the designers and the building control body having to think and apply their own judgment. So
chuck it out there, see what they think, and answer questions as you go. And that's all very good for the construction industry.
I don't think I'd phrase it that way.
How would you phrase it?
I think it's providing the best guidance you can at the time to support professionals making what are quite difficult judgments.
In your email to Mr. Baker at 1547, let's go back to that, please. Can we go back to it's CLG 1000585, the one you sent at 1547? You say there that you are positing that anything other than a homogeneous Class B board should somehow be caught by 12.7 of approved document B and should therefore be of limited combustibility. But you're also saying that a homogeneous Class B board would not be caught by the limited combustibility criteria. Is that, have I got that right?
Yeah, I think that's the point I'm trying to make, yes.
Yes, okay. Now, for absolute clarity, it's right, isn't it, that there is a definition of homogeneous given in EN 13501. We don't need to go to it, but for our records, it's at BSI 401738, page 10, paragraph 3.1.3. And I'll read it to you aloud. It is a product consisting of a single material having uniform density and composition throughout the product. I'll say that again. A product consisting of a single material having uniform density and composition throughout the product. Now, is that what you intended or understood by the word homogeneous in this context?
I don't know if I was specifically referring to the European definition. I was just using the word homogeneous, which means the same thing as far as I'm concerned, which is it's something which is consistent through its thickness.
All right. Now, to be clear, were you therefore positing that all elements of a composite rain screen panel with an outer skin and an inner core would need to be of limited combustibility?
No, I think what I'm saying here is the core would be.
Well, you don't know, do you?
I think I'm answering in the context of the question.
But what were you positing? Take a composite rain screen with an outer skin and an inner core. Were you positing here that both the outer skin and the inner core would need to be material of limited combustibility?
What I had in my mind there is that the core would be of material of limited combustibility and the surface could be Class B or Class O, but we were talking about European classifications on this.
But a homogeneous rain screen panel, in other words, not a composite, would not need to be of limited combustibility?
Yeah.
Where did you get that interpretation from?
That's my interpretation of the text as applied to a sheet that's essentially the surface.
Now, would you agree that there's nothing in diagram 40, and we're both, I think, very familiar with it for you to understand the question, but do you agree there's nothing in diagram 40 or in 12.6 or 12.7 for that matter, which tells us that a homogeneous Class B board is fine, as you would put it, at Class B, i.e. not of limited combustibility, but that anything else should be caught by the word filler in 12.7 and therefore be of limited combustibility?
When in the context of this question, they're talking diagram 40 talks about the surface. Surface isn't defined, and so you need to apply judgment to what it means, and that's the point I'm asking them to comment on, is do you think it's reasonable to treat, if you've got a thin panel which is a homogeneous material, is that not a Class B surface? Question mark. That's what I'm asking them, is do they agree that's a reasonable interpretation?
But you presumably knew, didn't you, I'm assuming this, maybe this is not right, that Class 0 was defined in paragraph 13 of Appendix A as it was, namely that the surface material, or where it's homogeneous or a composite product, needed to be composed throughout either of limited combustibility or of a Class 1 material meeting the various different indices. Surely knew that.
I think so, but I'd say I'm trying to address their question helpfully.
Yeah. So did it occur to you that there might be something wrong with the definition of Class 0 if one had trouble answering where the surface ended and the rest of it began?
I think it was a problem with talking about surface without being specific about what surface meant. I think that's the point I was getting at, is that you could read it different ways. What's a reasonable way that achieves the objectives of the functional requirement?
Looking at your response, do you accept that you didn't actually know the answer to Tony Baker's question?
Well, the answer I'm proposing is the one that I would apply and what I consider to be right, but I don't have absolute authority, and so I'm asking two experts in fire testing and cladding whether they think I'm right.
But you are the repository of the approved documents and not the BRE. I mean, leaving aside the contract point for the moment. Why would you need to think out loud and ask them questions whether it makes sense or not be quoted?
I don't have godlike knowledge of every form of construction and every technical question. So when somebody's raising something with me, especially people like Tony Baker and Sarah Colwell, who've got a lot of knowledge in this area, I want to test my views with them.
No, but you didn't need to be the almighty to know what was in your own mind when you drafted 12.6 and 12.7 in 2006.
Yes, and I've just said what I thought was in my mind, and I'm testing it with them to see whether it makes sense to them now.
Why? All that matters was that you reflected to them factually, surely, what you intended at that time. Just told them.
I think that's what I was doing.
Did this correspondence in November 2013 and your answer to him, couched in the way it was, not make it clear to you at this point that the guidance in 12.6 and 12.7 was not clear to those who would be using it?
I was aware that it wasn't as categorical as I'd have liked it to have been in 2006.
So I think that's a yes, isn't it?
I suppose, yes.
Right. Did it occur to you that, I mean, either at this time or any other time later, that far from being a goal which you wholeheartedly supported, as you say in your statement, achieving general clarity of understanding of statutory guidance on the fire safety requirements for external cladding on high-rise buildings ought to have been achieved by the publication of the guidance itself?
That's a desirable outcome, but it's my experience that it's very difficult to achieve. There are always questions that arise.
So, again, does it come to this, that ADB was really little more than an aspiration? Guidance with fingers crossed, so to speak? No. It was the best guidance we could give at the time based on the information we had. Did it occur to you at the time that it wasn't going to be possible for readers to arrive at a settled understanding of the meaning and remit of the guidance when you yourself hadn't reached any settled understanding in your own mind, but was simply questioning whether, and positing and asking the asker of the question whether your answer made sense?
So this is a kind of conversation that I would have a dozen times in a day on a range of different subjects. So I didn't see this as unusual, and was just doing my best to work with people in industry to try and get the best outcomes.
Right. I mean, did you not see your responsibility as achieving clarity in this guidance? In other words, a settled meaning and understanding which the entire industry could adhere to so as to achieve a uniformity of outcome?
Well, that would be a desirable objective, and something that I would have liked to have amended when I got the next opportunity.
You call it a goal or a desirable objective, and I think really what I'm having difficulty with, please help me, is why it's only a goal or only a desirable objective. Why isn't it the objective, the only objective?
Well, because at that time I wasn't rewriting approved document B and didn't have the opportunity to change it. So the question is, what can you do at that time to address that issue? And so I was doing the best I could.
So when is, on this answer, when is surface a surface and when is it part of the core? Where does the surface end and the core begin?
It's not defined. In my view, I think it's reasonable to treat, as I've set out here, I think it's reasonable to treat a homogeneous panel as being the surface. But if you've got a laminated product, then you ought to think about the material that's in the core.
Do you agree that the responsibility for... I'm so sorry.
Can I just butt in a second, because it occurs to me that there is a question here which perhaps Mr. Martin ought to be invited to comment on, and that is this. This whole debate, Mr. Martin, in a sense has been driven by the use of class naught as the criterion for satisfactory product on the exterior of a high-rise building. Now, we know that class naught has its origin as a measure of performance for interior linings. And what is passing through my mind is whether we ought to deduce from that class naught is only relevant if you're talking about an applied surface, i.e. the paper on the plasterboard or the paint on the underlying metal or whatever it might be. Now, if you take that view, you don't have this problem, do you, with the distinction between the surface and the interior of an homogeneous product? Do you have any thoughts on that? Do you see what I'm putting to you? Namely, that the whole concept of a surface which is related to class naught only applies in a case where some surface has been applied to an underlying material.
I guess in response to that, sir, if we're talking about a homogeneous panel, that's equivalent to a very thick layer of paint or paper.
Well, not really, is it? I mean, the homogeneous panel, if you imagine the piece of MDF or something like that, which is the same material all the way through, it has a surface in one sense, but not a surface to which the concept of class naught can apply.
Well, you can. You certainly could put a piece of MDF in a Class O in a fire propagation test and see whether you get Class O for it. I think there are Class O MDF materials available, sir.
All right. Well, there you are for what it's worth, Mr. Millett. If you want to follow that up, please do. If you don't think it's worth following up, just ignore it.
No, Mr. Chairman, I'd like to have a think about that a little bit more before I do. Let me just see how far I get with this line then. Can I ask you, Mr. Martin, do you agree that the responsibility for deciding definitions of words within government guidance or explaining them fell to government?
I guess the ultimate responsibility, yes.
Yes. And do you agree that in practical terms you were responsible for approved document B?
I was the desk officer for it, and the Secretary of State's responsible for it, if you're being pedantic, which I don't desire to be, but you've asked me the question.
No, fair enough. Yeah. Pedantry is sometimes welcome here, but you're quite right. As a matter of legal responsibility, of course, ultimately it's the Secretary of State's intention reflected by the wording signed by the Secretary of State. But in practical terms, you were the primary guardian, weren't you? The custodian of
yes.
approved document B. And as a custodian, did you regard it as your responsibility to explain the intention lying behind the guidance, particularly guidance that you had drafted, of the intended meaning of the words or provisions in it?
Yes, well, that's what I was trying to do in that email to BRE.
Yes. Now, there's no need to go back to the Baker correspondence, but does it surprise you to learn that Mr. Baker considered your response to be unsatisfactory? That's what he says in his fourth witness statement at paragraph 45.
I don't think he told me that.
Right. What about Sarah Colwell? Did she come back to you and pick you up on the response?
Not that I'm aware of.
Now, can we take it from this correspondence that neither the meaning nor the intended application of paragraph 12.7 was settled in your own mind in November 2013?
Its intent was what, as I described in 2006, was to get the designers to consider a range of issues.
Yeah. But it nonetheless threw up a question, or a question had arisen to which you couldn't point to 12.6 or 12.7 and provide a clear answer.
Its provisions aren't categorical, so they needed some interpretation.
So does that tell us that there wasn't a settled and understood meaning, in your own mind even, in 2013, of the meaning of 12.6 and 12.7?
In general terms there was, but for specific forms of construction, different questions would arise.
Right. So let's then just see if we can pin this down.
Okay.
In November 2013, to what materials or component parts of an external wall arrangement did the term filler materials, etc., apply, such that those materials should be of limited combustibility?
I'm not sure I could give you a definitive list.
So the answer is you don't know.
I guess if you pulled up a dozen different diagrams, I could come up with what I thought it might apply to.
Well, let me try it a different way. When you're looking at an external rain screen panel, take that as an object, a product. Was the requirement of limited combustibility limited to the core, or did it extend to the whole product?
You're talking about a composite rain screen panel?
You are right, I am, yes.
Then I would say it applies to the core.
And not the exterior, not the external surface?
Yes.
Were all external panels to be of limited combustibility, even if they were homogeneous panels with no core?
That's not the way I read it.
So does that tell us that the limited combustibility requirements in 12.7 only applied to panels which were not composed of homogeneous materials?
If we're talking, yes, I think that's correct.
Right. And was that your clear understanding in November 2013?
I think so, yes.
Mr. Chairman, it's 4:20. We're making some progress. I don't want to spend 10 minutes now wasting time on the next set of documents if I can help it. So it might be sensible to rise now, and I may be able to shorten the next part of the examination. I suspect it's 10 minutes for 10 minutes, but I'm in your hands.
Well, I'm sure that if you think it may result in shortening the examination, Mr. Martin, for one, will not object. And as long as we're making reasonable progress, I see no reason why we shouldn't break a little bit early.
We are making reasonable progress.
Right. Well, in that case, we'll have a slightly early afternoon. We can stop at that point. Mr. Martin, as you've heard, Mr. Minnitt's making good progress, and you won't mind if we stop 10 minutes early, I'm sure. We'll resume, if we may please, at 10 o'clock tomorrow morning. And I have to say this every time, I know, but please don't talk to anyone about your evidence or anything relating to it over the break. And as I say, we'll see you at 10 o'clock tomorrow. Thank you very much. Would you like to go to the usher, please? Thank you all very much. We'll break there and resume at 10 o'clock tomorrow. Thank you.